In Arizona, real estate advertising is not only a marketing activity, it is a legal representation of licensure and authority. The law is clear that only individuals and entities holding a valid Arizona real estate license may advertise, offer, or represent themselves as being able to perform acts requiring licensure under ARS Section 3212-2 and ARS Section 3216-5. Any unlicensed person who advertises in a manner that suggests they are engaged in real estate activity is effectively committing a violation of Arizona law and may face severe penalties. This rule applies equally to individuals whose licenses have expired, been terminated, suspended, or revoked, as well as to those who have never been licensed at all. The Arizona Department of Real Estate, ADRE, views advertising as a direct public representation of professional status. Therefore, even appearing to engage in licensed activity through advertisements, such as listing properties for sale, promoting brokerage services, or marketing oneself as a real estate expert, is prohibited unless the individual holds an active license. For instance, under ARS Section 32-2122B, it is unlawful for any person, corporation, or partnership to advertise or conduct business as a real estate broker or salesperson without a license. This law protects consumers from fraud, misrepresentation, and the unauthorized practice of real estate. To understand how this applies in practice, consider the following examples. If an individual posts on social media that they can help someone buy or sell a home, or lists a property as for sale by agent without holding an active real estate license, they are engaging in unlicensed advertising. Likewise, if a former licensee continues to advertise themselves as a realtor or real estate specialist after their license expires, the ADRE considers that a misrepresentation and an unlawful act. Even subtle indications, such as including a brokerage logo or offering to connect buyers and sellers for compensation, can be interpreted as unlicensed real estate activity. The penalties for appearing to engage in licensed real estate activity through advertising are serious. Under ARS Section 322165, the ADRE may issue a cease and desist order, and the violator may be subject to civil penalties up to $1,000 per violation if the act involves willful misrepresentation, fraud, or harm to the public. The Attorney General may pursue criminal prosecution. In some cases, individuals engaging in unlicensed real estate advertising have faced misdemeanor or felony charges, depending on the severity and intent of their actions. Additionally, if a licensed broker knowingly allows an unlicensed person to advertise under their name, the broker may face disciplinary action for failure to supervise and for aiding an unlicensed activity. A notable example illustrating these principles is found in State v. Carrasco, 1981, where an unlicensed individual advertised and collected deposits for land sales. The court upheld criminal penalties against the defendant, affirming that advertising and accepting funds for property transactions without licensure constituted the unlicensed practice of real estate. This precedent reinforces the ADRE's interpretation that advertising itself is an act of representation that implies licensure and therefore falls under its jurisdiction. Even inadvertent or mistaken advertising can create legal exposure. Suppose a salesperson forgets to renew their license but continues to run online advertisements or yard signs under the assumption that their renewal was processed. The ADRE may still treat those advertisements as violations because the individual was not actively licensed at the time the advertisements were displayed. In such cases, both the salesperson and their employing broker can face administrative penalties for failing to monitor licensure status and advertising compliance. This principle also applies to business entities. A corporation or limited liability company that advertises real estate services must be properly licensed through ADRE and must employ a designated broker responsible for all activity. If an entity advertises without being licensed, it is considered a separate and distinct violation from the actions of any individuals involved. For example, an unlicensed LLC posting a "We Buy Homes Fast" advertisement that implies representation or brokering could face civil fines and legal action, even if the owners are licensed individually but have not properly registered the entity. The ADRE frequently reminds licensees and the public that advertising is one of the most visible and enforceable components of the real estate law. The department regularly monitors online postings, signage, and digital advertisements to identify unlicensed activity. The appearance of professionalism, even without direct compensation, can trigger investigation if the ADRE determines that the advertisement gives the impression of licensure or the capacity to perform real estate acts. The consequences extend beyond fines and cease and desist orders. A person who has engaged in unlicensed advertising may face additional challenges when later applying for licensure under ARS. Section 32-2153. The Commissioner has the authority to deny a license to any applicant who has previously violated real estate statutes, including those related to unlicensed activity. Thus, even a single instance of unauthorized advertising can create lasting barriers to entering or re-entering the profession. Ultimately, advertising without an active license or appearing to engage in licensed activity through advertising undermines public trust and the integrity of Arizona's real estate industry. The ADRE's strict enforcement ensures that consumers interact only with qualified, accountable professionals who operate within the scope of their licensure. Licensees must remain vigilant about their advertising practices, ensuring that all materials clearly represent their licensed status, include their employing brokerage's name, and comply with all ADRE regulations. Review summary. Advertising that implies licensure without holding an active real estate license violates ARS Section 322122 and ARS Section 322153. Individuals who advertise as real estate professionals, post property listings, or offer brokerage services without being licensed may face cease and desist orders, fines of up to $1,000 per violation, and potential criminal penalties. Even unintentional or expired license advertising can result in disciplinary action. Brokers who permit or fail to prevent such advertising can also be held liable under ARS Section 32-2153. Discussion. Why is advertising without a license considered a violation of Arizona law? Answer. Because ARS Section 32-2122 prohibits anyone from representing themselves as being able to perform acts requiring a real estate license, including through advertising, without holding an active license. What are the possible penalties for advertising without a valid real estate license? Answer. The ADRE may impose civil fines of up to $1,000 per violation, issue cease and desist orders, and refer cases for criminal prosecution under ARS Section 32-2165. Can a broker be disciplined if they allow an unlicensed person to advertise under their name? Answer. Yes, the broker may be disciplined under ARS Section 32-2153 for failure to supervise and aiding an unlicensed activity. Closing remarks. Advertising is more than a marketing tool. It is a declaration of professional authority. In Arizona, appearing to act as a real estate licensee without proper licensure erodes consumer confidence and violates the foundation of the industry's regulatory structure. Every advertisement must reflect a licensee's active status, their employing brokerage, and truthful representation of their services. Upholding these standards protects not only consumers, but also the credibility of the real estate profession as a whole.